All right, and we're gonna call next up Hunter Brown versus Affinity Lifestyles. Let's go ahead and set forth our appearances for the record. We'll start first with the plaintiff, then we'll move to the defense.
Your Honor, Will Kemp, Teddy Parker, and Eric Pepperman for plaintiffs.
Morning, Your Honor.
Good morning, Your Honor. Joel Odou on behalf of the water defendants.
All right. And what do we have remote?
Morning, Your Honor. Matthew Sarnowski for defendant Silver Springs.
Good morning, Jim. Anyone else?
I don't know.
Good morning, Your Honor. David Spurlock, UNFI and Whole Foods.
And Jim Neal as well, Your Honor.
All right, good morning. All right, and I guess we have plaintiff's motion to strike Affinity Lifestyles and proper joinder.
Judge, we had one little housekeeping matter first. I talked to Mr. Odou, and given that we have motion in the hearings on Monday, Tuesday, and maybe Wednesday, we thought it would be a good idea to kick the pre-trial memo back to the 27th from the 20th.
That's fine. That's fine.
Okay.
Thank you, Your Honor.
Awesome.
No problem.
Your Honor, turning to the motion at hand. The fundamental legal issue is whether or not Mr. Henry, who had a liver transplant, can recover from loss of life expectancy. I don't think there's any doubt that there's loss of life expectancy because their experts said that. So what happened here is when Terrible Herbst was still in the case, they teed up this issue through a motion for summary judgment. We resolved our claim with Terrible Herbst, and they withdrew their motion. And then after they withdrew their motion, Real Water filed a joinder to the motion that had already been withdrawn. And so the issue really is whether under the local rules you can hop on the train after it's already passed you. And I would submit that they can't. I think the rules, I mean, it could be written a little better. It's a little ambiguous, but
I don't think you can, but tell me this, aren't these issues I'm gonna have to deal with anyway?
yes, I was just gonna bring that
I
up.
mean, we have two issues. We have shortened life expectancy, right? That's almost like the flip side of loss of chance.
Right.
In a fatal diagnosed cancer case. I mean, that's what jumped out at me. And then there's an issue, inability to have children,
Right.
infertility, I guess, something like that, whether that's a claim, you can make a cause of action for general damage. I get that. And so I'm looking at it from this perspective. And I never run away from any legal issue. We got to tee it up some way that's efficiently.
I was just gonna say, we are not trying to say that Mr. Odou has missed his opportunity to prove his virtue.
Right.
We're not saying that.
Yeah.
We just think the appropriate thing for him to have done would have been either to file a motion on an OST or to file a motion on OST now. To file a bench brief at the time that it's anticipated this will come up, probably either the opening of Dr. Hudson's testimony, or alternatively, he could have filed a directive verdict motion on this issue. Or third and finally,
Mr. Odou, I'll sign it order shortening time.
So, Your Honor, just to be clear,
I mean, really, because I have to deal with this before opening statements. I do,
Your Honor, and we actually thought the points of authorities by ETT were fine. Certainly, I could copy and paste them.
I mean, it's your decision.
Just letting plaintiff oppose it, and then I'll reply, and the issue's
We
ready
can
to
do
go.
that too.
that's fine with us, Your Honor.
That's fine. Whatever we want to do from an efficiency perspective is okay with
Yeah, I don't
me.
know if we can get it done by next month.
No, whatever plaintiffs need to oppose, and then we.
We can hear it on the last day of the in limine, whatever. It doesn't matter, but I have to, or pre-trial motions.
Today's Wednesday, and the motion we're hearing is Monday, Tuesday, and Wednesday.
Yeah.
I don't know if it can be teed up quite that.
No, but I actually have more. We only need 3 days.
Hopefully, yeah.
Yeah, but I have set aside.
Yeah.
Yeah, I got extra time.
Plaintiff wants to file an opposition, we'll file a reply like 2 days later.
Yeah,
The
that's
issue's
fine.
ready to go.
Okay. Thank you, Your Honor.
And what you can do, you can call land. What dates did we set aside for this? I know.
So we have the 23rd, 24th, and 25th, and then we have all day, Monday the 30th, October 1st and 2nd, we can start at 10:30 a.m. But the 3rd and the 4th are now taken by other sessions.
Okay, so there you go.
Yeah, sure. While we're talking about the motions eliminated, it's our hope that we can get done on Monday, Tuesday.
Yeah,
Just
Right.
because there's really not that much left.
there isn't.
So just as a tippler, should I continue this motion to the 23rd, and then once all of that's taken care of, we can set it on the session, but just so that we don't lose it?
Yeah, we can do it that way.
Okay.
That's fine. That's more housekeeping than anything, just from a scheduling perspective, to make sure we don't lose it.
That
And,
sounds great.
and that's what
We're
we do.
starting Monday,
At 9:30.
9:30.
9:30, yeah, because I have to deal with these issues, and I'd much rather do two things. Number one, develop the record. Number two, have a chance to read some of the cases and then make the decision versus, because I mean, I can grant the motion, and I think, yeah, I kind of agree in this regard. It's a little problematic, but I got to deal with it. Mr. Odou, you know that,
Appreciate it.
yeah.
Yeah, no, we just wanna, we'll make our record and the court call ball or strike and we'll move on.
Exactly, that's all I can do. And lastly, is this case going to settle?
No, Your
Yeah, unfortunately not. There are issues with the interpleader, maybe that gets refiled, who knows? I mean,
I understand. I'm just kind of surprised. This is number 4 now.
yeah.
Okay.
We have some all three cases.
No, I understand that. I was just
Yeah.
thinking,
Is there anybody left in any of the cases?
In the fifth case, there's still, Nevada beverage for,
In Quebec?
no, not Quebec, I'm talking about the one in February.
Oh, the board, yeah.
Board name.
February
So on board name, she still has Nevada beverage and Robinson, and Nigel, last name wait for now, has,
Nigel Davis.
he has Nevada beverage.
Okay.
And we're thinking that the expert discovery has to be developed in those cases.
Yeah, I was gonna talk about that in those cases too. Yeah. That's before this court.
right, I understand. And I just have one last comment, and I think this is important to point out, because I remember when I actually read the underlying points and authorities. I don't mind telling you that. And there was one comment made regarding, I think it was a Ninth Circuit case that stood for the proposition that, yeah, Nevada, if there's no law, we follow California law. That's not true, especially in tort cases. Right? And in fact, I mean, you look in, we handle insurance law completely different than California, when it comes to bad faith, the offsets for med pay, and the list kind of goes on and on. And so I don't know where Nevada fits on a national level, but we're separate and distinct from California in that regard, I think, and generally, and as far as court law is concerned. Yes, we follow them sometimes, but it's not like we're in lockstep with California. In fact, because we're different, we are. I think we're more closer to Montana and places like that. Actually, that has a fairly progressive tort system. But those are just my overall comments based upon what I know. But we'll get it done, and I guess we'll have. This is a side note. We've already sworn in our first panel of jurors. We're having some problems in this regard. We're not getting as many responses as we would like. How many did I swear in yesterday?
64.
64. And how many did we subpoena for that session? Was supposed to be 100, right?
I'm not sure, but we definitely have more coming in today.
Yeah. See, I'll see him again today, and but it is what it is, and we'll get a case tried. I'm not worried about that.
I think that was more so a jury services issue though, because Mariah said that the notification, it's a brand new system that we just started. Mariah said there was something with the notifications that she took care of that, so
Okay.
they're gonna be put at the back.
Yeah. But we'll get the case tried. That's the bottom line, because we need closure. Anything else, Mr. Park?
No, that's great, John. We actually didn't need as many jurors, potential jurors the last time as we thought, so.
Yeah,
it worked out.
I'm not worried about it. I can always get another 500, Mr. Park.
So, Your Honor, just so I'm clear, the plan is for Mr. Odou to file his own motion for.
No, I think he's gonna rely upon.
Let's go on the ETT. You guys oppose, I'll file a reply to your opposition 2 days later. And we could do it on the 30th or whenever the court has time.
Right. We'll get
What's
it
our
done.
opposition to?
When do you, really, it's how much time do you guys need?
Maybe Tuesday,
Yeah,
Monday, Tuesday.
that's fine.
Whenever, it'll be fine.
Sounds good.
So wait, before you go, shouldn't we set it so that?
Yeah, it's on the 23rd, just as a
It's gonna be
check.
continued to the 23rd. It's not gonna be argued on the 23rd, but we'll set it sometime in then.
Okay. All right. Just want to make sure we don't lose it.
Sounds good.
Thank you, John.
Okay, everyone enjoy your day.